crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome to the attorneys. Thank you so much for joining us on this Sunday evening. A really interesting topic of conversation, a great panel. The only thing that would make it better is your involvement, and here's how you can be involved in the show. Plenty of ways to do so. At the bottom of your screen, you'll see ways you can call, text, email, however you choose to get in touch with us. Would love to have you do so there. Also, attorneys from Hollis Wright are standing by live all throughout the program tonight. So a really neat opportunity to get some free, confidential, and off-air legal advice tonight during the show, so you're going to want to take advantage of that. The numbers to know, 844-LAW-TALK. You need to write that down somewhere. That's the number that will always get you to Hollis Wright. That's 844-529-8255 or locally at 205-324-3600. Leading our conversation is the managing partner of Hollis Wright, Josh Wright. Good to see you, sir.
Good to see you, too. How you doing?
I'm doing well. How about you?
Well, good. We're doing real well. Firm's doing great, and just happy to be here for another week.
Busting into a new year and coming strong.
Absolutely, no question. We're going to be doing a personal injury-related show tonight related to premises liability, and we're so lucky to have Kimberly Perkins on.
Okay.
First of all, welcome.
Thanks.
First time on the show.
It is.
I told you this was going to go by quicker than you thought it was, and you watch. It's going to go by quick. But we're excited to have you on as kind of an expert in this area. And we're going to be talking a little bit, David, about premises liability related issues. And it's really kind of a complicated area of the law where people are injured on a premises, whether it be at a store or as a guest at someone's business or at their home. And kind of the implications of how the law can protect them in circumstances where someone has really not dotted the I's and crossed the T's and has caused or contributed to the injury itself. So super happy to have you on to be able to talk about this issue.
Oh, happy to be here.
All right, so tell us a little bit about your firm, Lloyd & Hogan. Tell us a little bit about the firm and kind of how you got started in this area of the law.
Well, Lloyd & Hogan is a plaintiff's firm, and what that means is we pursue cases such as personal injury, includes a lot of slip and falls, automobile accidents, medical malpractice.
So you have gotten into this area of the law, though, and it requires you to actually understand some things, really understand some things like whether someone qualifies as a licensee, an invitee, a trespasser. I mean, those are kind of complicated legal issues that is not as simple as you think, figuring out what the standards are.
That's correct. A lot of people think, hey, if I walk into this place of business and I fail, I'm going to get rich. It's not that simple. Yeah. That area of the law is very intricate, and it can be difficult to prove a claim.
So let's take these standards. As I've always understood the premises standards, Kimberly, you have one standard that is higher than another, trespasser being the lowest standard. Correct. And kind of what a property owner owes. Let's take it one step at a time and let's kind of work our way through it. So
sure. How
does it work?
So if you're an invitee, that's someone where you're into their business, and you're there for the benefit of the owner. So you're there to make a purchase or conduct business. And a licensee, you are a guest. So if you're a guest in someone's home, in both of those, the owner has a duty to make sure that the premises does not have any dangerous conditions, that the floor is maintained, walkways in particular, the carpeting is not deteriorate in a way that could cause a hazard, just things like that, making sure it's a safe area to travel in because they know people will be traveling that area. And
I find, David, a lot of these claims don't always arise just out of a slip and fall or what people call a trip and fall. They relate to structural related issues like lack of appropriate barriers around heights, or stairwells that have become defective or have failed, that a property owner or someone that's at a facility may have a responsibility to protect. So a lot of times these come out of injuries, and we just had a recent injury related to a hole that caused a catastrophic, life-changing injury for a child. that was running and did not know in a certain area. And so it doesn't always just relate to issues of slip and fall. Sometimes it will relate to more serious injuries and more serious accidents without question.
You know, there are issues like this oftentimes are covered on the news, but what seems to get the most attention are individuals trying to be negligent and you know, now everything is captured on video, right? Yeah. And somebody faking the fall and that sort of thing. Is this a particular area of the law where there is a great deal more fraud type of activity than the others? Than other aspects?
Yeah, I don't know the actual statistics on that, but I would say that it has become, like you said, people see it on TV, and we're in just more of a litigious society in general, so people, you know, think, oh, I can get rich quick. I think one of the things that we saw a lot of those cases is the nature of the injury. You just mentioned a case where you had a catastrophic injury, and those are going to be taken a lot more seriously than someone, oh, I fell and my hip hurts. I don't have any medical bills, but I'm sore.
Yeah.
You know, that's one way a lot of those cases kind of get weeded out.
Yeah. Another thing too is the age of the individual. A lot of times we find that having younger children and having older elderly adults are more susceptible to injuries at various premises. So, you know, that also is weighed in by the jury. And, you know, look, juries get it right a lot. So, you know, a lot of it comes down to what evidence do you have and what can you prove. Juries can smell out if there's someone that's pushing the bounds and overreaching in a case. And I do believe the system's not perfect, but it's a practical system that works and allows us to use juries to be able to weed out some of those claims that you're talking about. Let's talk just general terms. Let's take a premises, grocery store. What standard is a grocery store subject to, for example, if they have some defect on their property that is contributing to an injury?
Well, the first standard is to warn of the defect. So you may not be able to jump on it right away and get it fixed right away. Warn of it. Put a sign out. You know, if your freezer's leaking and there's water all over the place, put a wet sign out. Let your customers know that hazard is there. And then, of course, the next step is to get it fixed as quickly as possible so that condition is no longer present and no longer a hazard to your customers.
Is it basically just a reasonable care standard? Is it almost a negligent standard for a grocery store where someone is coming to purchase products there? Because you had talked a little bit about an invitee versus a licensee. Under the lowest standard, is it basically just a negligence reasonable care standard?
Absolutely.
Okay.
Yeah.
So if you're establishing one of those cases, you're trying to figure out whether or not they put appropriate warnings out, or whether or not their lack of immediate warnings or lack of reasonable care in fixing, for example, as you mentioned, a freezer, is a contributing cause to the event.
Absolutely.
Okay.
Absolutely.
And so where do you come into most commonly the licensee side, which is not where you and I go to a grocery store, you and I go to a department store, you and I go somewhere to shop, but in circumstances where you could have a licensee circumstance?
Well, probably if you're a visitor at someone's home, you know, let's say you're at a party and there's an outside party and you fall on a deck, or there's some type of broken structure or stairs and you trip and fall on that, or you fall and break a leg. Yeah. In that instance, you were a guest at someone's home, and if they had a condition they knew about, didn't warn you about, and as a result you are hurt, then that's a case where you're a licensee and you may have a claim to get compensated for your injuries.
Yeah, and that is basically to warn of concealed injuries. And I know we're getting ready to go to break, but let me give you one shining example that I know Kimberly will be able to recognize falls into this category, and that is deck failures. And we've had some circumstances where we've had cases both on college campuses and also in more residential circumstances where there's a deck failure, where maybe a property owner had knowledge there were some issues and they packed too many people on that deck and can cause some very serious and significant injuries. And so those are circumstances where the standard has to be identified by the attorney, and then you've got to go prove your claim.
All right. We're going to step aside. Our first break of the evening right here. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
If you sustain an on-the-job injury, it can devastate you and your family. That's when you need the help of Hollis Wright. Our attorneys are right here in Birmingham and have decades of experience representing injured victims. We have handled on-the-job injury cases in every county throughout this great state and would be proud to help you. If you've been injured in an accident, always make Hollis Wright the first law firm you call. At Hollis Wright, results matter.
I started practicing law more than 20 years ago with a mission: advocate for personal injury victims in their darkest days. Recognizing that there were others who stood with me in that purpose, we built the Hollis Wright team from the ground up. Now with 25 employees here to help personal injury victims when they need it the most, our team is here for you. If you've been injured in an accident, always make Hollis Wright the first law firm you call. At Hollis Wright, results matter.
Welcome back into The Attorneys. Before we get back into the conversation, don't forget, attorneys from Hollis Wright standing by live right now to speak with you. That free, confidential, all-fair conversation is yours for the taking. Talking about premises liability tonight, got a couple of questions that we're getting on trespassers. So if you own a business, or even if it's in your home and someone trespasses on your property, are there legal issues there? Might they have a right to claim someone that trespasses on your property?
Well, a landowner doesn't owe a duty to a trespasser, but what they can't do is willfully and intentionally set up, say, traps or any type of dangerous condition for a trespasser.
Right.
Yeah,
Like a bear trap. You can't put a bear trap for it.
Right.
Well, you know, where you see it often is in like hunting, you know, in hunting land, and somebody wanders accidentally. Sometimes trespassing is not always intentional. Yeah. So someone wanders onto someone else's property in a hunting event, and they fall in a well that they didn't know was there, that had been covered up. And then the evaluation is whether or not there's a viable claim or not. And so you'll see it in circumstances like that. You also see it a lot, and we talked a little bit about age earlier, about elderly people and injuries and minors. And you see trespassing a lot with minors where they may not have any ill will whatsoever, but they don't have the maturity level to understand what they're doing is dangerous. Construction sites, pools, things like that.
Right.
How do you evaluate those claims? Because I know with children, the standards do change just a little bit.
Right, and in the law we generally call that, as you know, attractive nuisance. And that's basically saying there's a condition, usually man-made, on your property that could be attractive to children. A swimming pool, for instance. A 5-year-old that can get into your swimming pool, their case will be evaluated differently from a 16-year-old per se. So if a 5-year-old wanders into your property, gets into your pool, is injured, or heaven forbid, dies as a result of an injury in your swimming pool, the law will look at the conditions that you and safeguards that the property owner put into place to prevent that from happening. And that condition and those safeguards will be looked at differently from if an adult was injured. So if you had a 10-foot fence around your pool as opposed to no fence at all, the law will look at what you did to try to prevent anyone from, namely a child, from entering your property and getting injured.
Yeah, and you know, I'm sad to say, and I know Kimberly sees it too, I've handled way too many minor pool drowning cases, and they're horrible. They are so emotional, and a lot of times what we're doing is simply evaluating whether or not the homeowner who knew they had children around them had done the very small things that are necessary to protect against attractive nuisances. and that requires fencing, it requires other potential equipment. And so a lot of times that is the evaluation that's being done, is to determine whether or not they met the minimum standards required by their local city or their county. Sometimes there are county standards that are applicable, and we've handled just way too many of those cases, and they're real sad cases. You know, a 4 and a 5-year-old kid doesn't understand how dangerous that can be to them. It is an attractive nuisance to go to, and you know, there's property owners have standards and things they've got to follow too.
That's terrible.
Yeah, no, it's bad. All right, let's talk. Let's get back to just generally proving a claim. In general terms, getting a lawyer involved is important, but what do you have to prove in order to be successful in a premises claim?
Well, you've got to prove, first of all, that the person that you're trying to sue actually owned the property. And then you have to prove that there was some type of negligence that occurred, that the floor was negligently maintained, the stairs were negligently maintained. There was some negligence in the way they maintained the property. And then the third thing is that because of that negligence, you were injured. And the fourth thing, and this is where a lot of people kind of lose their way in their claim, you've got to prove that that negligence was a result of your harm. And what that means is, for instance, if you slip and fall on a floor and you hurt your hip, but you already had a pre-existing surgical recommendation for that same hip, you can't necessarily attach your hip surgery to that slip and fall. So it's about proving the claims you're trying to assert are directly related to the injury that you sustained as a result of that negligent condition.
Yeah, and that's one of the reasons why you want to have a lawyer involved in these claims, because a lawyer a lot of times can talk sense into a client to say, hey, you know, we do not need to overreach on this claim. There was a pre-existing, for example, surgical recommendation there, but you have a legitimate broken arm here and a, you know, fractured patella, whatever. And those are new and legitimate claims related to this conduct. And so those are the things that we're going to present, as opposed to trying to present everything. And so sometimes having a lawyer lead, guide, and direct you through the process, as we often says, is super important in these cases.
I have a friend who owns a restaurant, and whenever they pressure wash the restaurant, there will always be water leak in the store. They do it like quarterly. And my friend will put out a yellow, you know, one of those yellow signs, you know, wet floor. And someone came in and slipped after that had happened, and they did get injured. And he was told that just putting that sign out saved him. That his insurance, whoever said that small, simple action, just that heads up, saved him from being the one and have, you know, being liable for that.
Yeah,
I mean, that's such a small thing.
Yep.
I mean, that took him how long to do that? Like 1 minute.
All right.
But it is kind of letting folks know, like what you guys are talking about.
Yeah, and that goes back to what you were talking about earlier, is warnings.
Yeah, give them warnings, give them notice. Put that sign out, like you said, it could save you a lot of hassle because you've given that person notice, this floor is wet.
Right.
It sounds so common sense, but just omitting that one act can cause you a lot of headache.
You know, and David, the law also protects companies. I'll give you a good example. We have some rules about whether a typical person, a consumer coming to a store on a rainy day, within certain distances of the door, if they slip and fall, the law protects the property owner in most circumstances and cases. That basically it dictates that the individual customer should be aware and have knowledge that there are potential slip hazards, for example, on rainy days. That sounds so simple, but it's a protective insulation that does protect a level of businesses out there. And so, you know, the law is pretty practical to help businesses be able to operate without having to be so vigilant. However, there are things that happen all the time in your store that you got to be more careful of.
Having hosted a few hundred of these shows, I think you attorneys are a little paranoid, but in a good way, because I think what you have seen so much, your brains are almost like, okay, what needs to happen so there's no liability there? And I think homeowners, business owners, in a sense, need to think that same way.
Yeah.
You know, like, what can I do just in case?
Yeah,
You know, that
that's
sort
right.
of thing. All right, we got to step aside. Our final break of the evening. One more break. As we do so, a quick reminder, a great resource is how Hollis Wright uses social media. Head to Instagram, Facebook, Twitter, you name it, they're on there, even YouTube channel. So just search them out. Hollis Wright, find them there. Great informational, educational resource. Stay tuned. One more final segment of The Attorneys coming right up.
I'm attorney John Spade with the Hollis Wright Law Firm. If you have ever had a personal injury claim, the attorney handling your case has likely told you that a portion of your settlement would have to be used to pay back your health insurance company for the medical bills that they paid relating to your injuries. This is called subrogation. In this week's Legal 411, we are answering the question, what is subrogation and how does it affect your personal injury claim? When you purchase health insurance, you sign a contract with the health insurance company, which provides that in exchange for you paying a monthly premium, the insurance company will pay your medical bills when you're injured. Now, that contract has a paragraph that gives your health insurance company the right to seek repayment for the medical bills they paid if you in turn use those medical bills as a basis to recover from a third party that caused your injury. The idea is that your health insurance company would not have had to pay your medical bills if it weren't for the wrongdoing of the third party. Now, health insurance companies routinely put attorneys on notice of their subrogation claims by outlining exactly which medical payments the health insurance company is claiming a subrogation claim for and for what amounts. Throughout the handling of your case, your attorney should be aware of the amount of subrogation your health insurance company is claiming and whether all the claimed subrogation is related to your underlying personal injury case. That way, if your case resolves, your attorney can then negotiate a reduction of the health insurance company's subrogation claim. Subrogation is one of the many moving parts that can affect your personal injury settlement and what you stand to recover. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and our promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into The Attorneys, our final segment. You want to speak to the attorneys from Hollis Wright. Quickly take advantage of that. About 5 minutes remaining before this show wraps up. Josh?
All right, so Kimberly, talk to us about this. What generally is we talk about limitations of actions or statute of limitations, meaning how long you had to file suit. How does that normally work in these cases?
Well, injury from a premises liability claim is 2 years, like all of the personal injury cases.
And do you think it is important to get an attorney involved immediately in these cases? Because I know sometimes I get people that call our firm that say, I've been working with an insurance company for so-and-so facility because, you know, I had 2 surgeries related to this issue. What's your recommendation on that?
Definitely get an attorney involved. I mean, just like you said, they say they work with an insurance company. That insurance company does not work for them.
Yeah.
They need to get an attorney on their side that works for them, that knows the law, that knows the nuances of cases like this, and can make sure that they are getting their best chance at maximum recovery.
And what do you see most often as far as your premises claims? Is it the person that slips on a rainy day? Is it defective equipment inside a facility like a ice maker or something that broke? I mean, what do you see most often?
I think it's more the latter. It's not so much rainy day cases because that's an open, obvious condition. But if there's, like I mentioned earlier, a faulty freezer that's created water on the floor, broken steps, poor lighting above the broken steps so you can't even see it. Things like that can lead to claims like this.
You mentioned open and obvious, and that is another insulating factor that protects property owners a lot of times. Explain just a little bit about what open and obvious means and how that is a defense.
Well, unlike, we talked about earlier, putting a wet floor sign out if you have a broken freezer that a person may not be aware of. If it's raining outside and you enter and you're wearing, flip-flops, and then you walk into a store with hardwood floors, you know that it's raining, you know what kind of shoes you have on, and you know what kind of floor you're walking onto. So it's almost like you have noticed that a floor covered with rainwater is slippery, as opposed to that freezer in the back of the store that you didn't know was leaking.
Yeah. So if a property owner is able to prove that the defect was open and obvious for others to see, they're insulated from that suit, aren't they?
In most cases.
Yeah. So that's just a good example of the law does protect property owners a lot. And David, we talk a lot on this show about folks that are doing it the right way, doing it the wrong way. There's a significant difference between a slip and fall because of rainwater and a company that was aware that they had a leaking piece of equipment and did a bunch of maintenance on it and decided not to replace it, and that caused someone to end up with 2 surgeries with a blown meniscus, right? So we try and walk the line here on the show a little bit about making sure that people recognize we see that there are people taking advantage of the system, but also there are legitimate, viable claims where people need to be compensated. And so, those are just a couple examples.
Yeah. So it's less about gotcha and more about just be responsible.
That's right.
Yeah, for your property.
That's right.
All right, time for us, just a couple of minutes remaining in the show, just time enough for a final thought from the two of you. And if you would, you go first, please.
Absolutely. Again, I would just say if you think you have a claim, reach out to an attorney. You're not required to, but it's for your benefit to hire a professional that handles cases like these, that sees them all the time, knows the nuances of them, and knows the law. Getting an attorney on your side will make sure that you are maximizing your potential recovery and helping you to be compensated for your injury.
Well, first, let me just say, I knew when we brought Kimberly on the show, she was going to do a great job. It went a lot faster than you thought, didn't it?
It did.
Yeah, I mean, you did a good job too, because you understand this area of the law. So, number one, we're really happy to have you on.
Thank you for having me.
David, I think that it's important to get a lawyer involved in circumstances where someone has been injured on property. And these types of premises claims come in a lot of shapes and colors and sizes. They're not always trip and fall and slip and fall cases. They are hunting accidents. They are falls from banisters. They are stairwells that are defective. They are porches that fall and cause injury. Premises liability is a complicated area of the law, and having a lawyer get involved that can lead, guide, and direct you through the process and tell you, for example, as Kimberly described to us, what the standard is, whether it's a trespasser, a licensee, or an invitee, and how those standards apply is super, super important. Right. And if you don't get a lawyer involved and you try and navigate it on your own, what you may find is that you're not able to prove the standard that you needed to when you have a viable and legitimate claim that needs to be compensated. So that's just a good example.
Good show. Both
Absolutely.
Of you. Good job.
Absolutely.
Appreciate you being with us. We need to have you back again soon.
100%.
For sure.
To.
Great job.
Yeah.
You did good.
Thanks so much to you. Thanks to you for joining us as well. We appreciate it as always. We'll look for you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.